It will be very short, and thank you. May it please the court. Crystal Jesse from the Greene County Bar. I represent the appellee. I have tailored down my argument since the appellant has waived hers, but there are a few things that I did want to bring before the court to make sure I specifically pointed out. As to her second argument, the best interest argument, I will simply rest on my brief as to the facts, but I wanted to make sure that the court noticed that the trial court found that it was in the best interest of the child for the termination on 2 occasions. You have the original July 3rd, 2024 trial date, in which the trial court goes through the facts ad nauseum. I quoted them in my brief. Then we come up on appeal. If you recall from the record, while on appeal, the trial court then puts down an order that it wants to make additional findings and change and modify some of the findings from the July hearing. The trial court did that in December. Even though the trial court made additional and modified findings, it did not change its determination that it was in the child's best interest for the termination to go forward. So on
Ms. Jesse, let me ask you this. I know that the trial court orally went through the best interest factors.
Yes, Your Honor.
However, in the order, he did not incorporate his oral findings into his order. My question to you is, how can we review his best interest analysis when the order just says it's in the best interest of the child?
I understand that, Your Honor, and I noticed that was missing, and he cited to it the second time at the second hearing, and that's something that could be clarified on remand for him to physically adopt and not set aside the termination in and of itself, because he was very specific in the findings, and I did quote them verbatim. So I understand that, and that they did get omitted from the order. As to her first argument, which I will now address, it comes down to a sentence. Punctuation matters. She brought before the court and said that my client was not a proper party to the termination. There were no pleadings as to that prior to the hearing. If you'll notice in the record and on page 13 of her brief, she states exactly what the trial court said at trial. So at the close of proof, the trial court comes out and quotes 36-1-115C. And the trial court said verbatim, if the petitioner has a spouse living, comma, competent to join the petition, comma, such spouse shall join the petition. The trial court ended at that, as if there was a period. And that's why I say punctuation matters. As I pointed out on page 11 of the brief, of my brief, the sentence doesn't end there. We have to look at it in totality. There's a semicolon, and it goes on to say, provided that if the spouse of the petitioner is a legal and biological parent of the child to be adopted. So that specific statute takes into consideration a step-parent adoption. That's not
but
what,
only that section of the statute.
only that section of the statute.
So the first part, which is the applicable part, is not limited to step-parent adoptions.
It's one sentence, so I don't know what you're referring to. The first part, 36-1-115.
Where the colon is, or the semicolon.
It is all written in one sentence with the semicolon. So I took the plain language in section C is all one sentence with the semicolon as to a step-parent adoption, because you read it in totality. And I based my opinion on the Basket versus Straight case. There's no case on point that I can find. That's a 1900 Supreme Court case. It's not a termination or adoption case. It's a custody case, though, that references and goes through the adoption statute. In that case, the Supreme Court pointed out that Tennessee is not a joint application requirement state. It also,
but that case is from 1900.
Yes, ma'am.
Well before our adoption of this, or our adoption of the statutory adoption scheme.
Many parts of the adoption and termination statutes have changed. However, the only joint application portion that has changed is referenced as to the step-parent adoption. So when you read the plain language in totality without a period there, because it's a semicolon, it's referencing a step-parent adoption.
So you think in Tennessee, if you have married parents, it's your position that one parent can petition to adopt a child without the other parent joining in?
Not
Unless it's a step parent.
It's my position, if I understand your question right, that in Tennessee, you can have an exclusive adoptive parent that files for adoption, and that exclusive adoptive parent can be married to someone else, can be married, and their spouse not join the adoption.
I don't know about that.
Excuse me?
I don't know about that.
I understand. I can't find a case on point, and that's why we're here today. Because as my reading the plain language of the statute, it did not change, and at no point in time in the statute, anywhere else does it say where a joint application requirements state.
I think your better argument is probably the other one, where you say regardless of that, what happened in this case was just a termination and not an adoption.
That is my better argument, and I haven't gotten to that yet. So going forward with my argument, after you read the plain language, my second portion of that argument in my brief is at the beginning of the trial, if you notice, in July, I asked very specifically for the trial court to take into consideration whether we're going to do the termination and the adoption, or the termination or the adoption. And as the judge said at that point in time, he was taking up the termination to see then if there would be appeal after the termination, and then take up the consideration of the adoption at that time. So even if the court believes that I'm wrong in the plain language of the statute, and that it doesn't just apply to a step-parent adoption, that this is premature. The adoption statute was not taken up at that time. The only thing before the court was the termination of the father's parental rights. It was not addressing the adoption of the child. With that being said, and as I mentioned previously, I've tailored my argument down very specifically. Do your honors have any other questions?
No other questions?
Thank you. Thank you very much.
Thank you. Thank you both. Would you call the next case, please?
Angela Winston